was more along the lines of occupational health and safety. This directive then permits any employer to implement the development of a policy, and this policy would make vaccination mandatory for all employees. But however, there are subjects to issues that the employer would have to do to make sure that the policy development encompasses all the necessary protocols. For instance, there needs to be a risk assessment as to what convinces the employer that there is a need for such a mandatory vaccination exercise. So an assessment would have to be made. And second of all, once that assessment has been made, then there must be then the development of that policy. And then that policy, in terms of that directive, I think it's Directive 3.1, if my mind serves me correct, then it would assist the employer then to make it mandatory. And there's also two things further to that the employer would have to do in terms of that direction, is that how the mandatory vaccination is related to the operational requirements of the business of the employer. And also the policy would have, or the assessment would have to say loudly and clear as to the category of employees that would have to be vaccinated. So to answer your question in a short manner, yes, there is a regulation that gives employers permission to be able to mandate employees to be vaccinated.
Well, my second question to that then will be follow up, because if they are allowed, they're permissible to make it mandatory, well, then they will have to then come up with a policy that is applicable to all employees. Well, we know that some people, and we've seen this on so many websites, different social media accounts, people saying different stuff, some against taking of the vaccine. Well, we know that there will be employees who are saying, well, my church or whatever religion basis they will rely on, but they will just say, I won't pitch up at the vaccination center. And some will even say, I have a right to bodily integrity. Well, some of those defenses, do you think, as a labor lawyer, will hold water?
As you have correctly highlighted, the objections or the points where employees might raise objections to vaccination, those are normal defenses that one would get to in issues of this instance. As you have raised, Section 12 of our Constitution provides for no interference that is unreasonable to our bodily integrity. Now, however, in terms of this directive, if we were to go back to the directive itself, it also raises two instances where one or an employee may raise an objection, and one of which is a medical condition, and the second of which would be the bodily integrity. If now we were to start with the one that you have asked, the right to bodily integrity, the Department of Labor, in this instance, urges the employers to make sure that they respect this right of bodily integrity. In other words, in their process of doing their assessment, in their process of developing a framework to implement such a policy, there must be a consultation, there must be a sense of mutual respect, there must be a balance that would have been struck between one, the protected rights of employees, and two, the imperative that is there of public health, that everyone must be protected from by the state in this instance. And the third leg would be there must be a balance also that considers the operational requirements of the employer's operation. So, in other words, the right to bodily integrity is just like any other right that we hold or we have that is enshrined in the Constitution, is subject to certain limitations. Section 36(1) of the Constitution provides that those rights sometimes may be limited, and may be limited to the extent that as long as the limitation is reasonable and justifiable, based on, say, for instance, human dignity, equality, and also the importance of the purpose of the limitation, as in this instance, the issue of public health and the pandemic that the whole world is trying to grapple with. So those arguments then would have to be factored in and see whether they don't sway the scale towards the tampering with the bodily integrity part of it. And then you've also raised the issue of religion, whether people can raise religion or cultural beliefs as an objection for them taking the vaccination. That is true. That is well established in our labor law provisions or regulations. An employee may object to be vaccinated or on the basis of their religious beliefs. It could be sometimes that the employee would raise that there are substances within the vaccine that are prohibited in terms of her beliefs or religious tenets or fundamental teachings, or sometimes cultural beliefs. But however, when an employee raises that as a defense, the employer then would have to assess whether that is so. In other words, test that objection of its veracity and make sure that it's grounded and it's true. And on the basis of that, then the process would also come in that, remember, the last leg that we have raised earlier is that has to be considered in all these scenarios is the operational requirements of the employer's operations. So now, once all has been done, when I say all, I mean the consultation with the employee. Two, the directive makes provision for an accommodation that has to be provided to the employee. Yes.
Mr. Keza?
Yes. I can hear you. Can you hear me?
Yes, I lost you for a second, but you can continue from where you left. I just saw that we are having some connection problem, but you can continue.
Okay. Where was I, if you were to direct me so that I know where to?
Well, you were talking about operational requirements that the employer will have to show that the employee no longer reach the operational requirements and therefore have to go to a vaccine, if I heard you well.
Yeah, all right. Fair enough, Mr. Tladla. Thank you. Now, once the employer has one, consulted with the employee, two, after consultation with the employee, the second point would be to accommodate the employee. Once an employee has made a compelling case to say, because of my religious beliefs, I cannot be able to be subjected to vaccination, or because of my cultural practices, I won't be able to take the vaccine. So the employer then has an obligation put to him or her by the direction issued by the Department of Labor. And then the directive then obligates the employer to make provision for the accommodation. Now, if for whatever reason the accommodation is not sustainable, or the fact that the accommodation could mean anything, could mean that the employee would have to work from home, or the employee would have to make sure that he or she is constantly wearing a mask and observing all the non-medical processes to protect ourselves from COVID. So if all those fail, then the employer would have then to subject the employee to an operational requirements inquiry, where the employer would have to assess whether the relationship between the employer and the employee is contributing positively to the operational requirements of the organization. And in some instances, the directive makes provision for that the employee can be dismissed on the basis of operational requirements once all has been exhausted. But the directive is very emphatic on the fact that that should be a last resort. That should be a last resort. Employers are urged or cautioned to try and exhaust all other possible alternatives before they resort to the last one of dismissal on operational requirements.
All right, thank you for that substantive explanation. It clears a lot and it preempts some of the questions I wanted to ask in the next segment. But just to continue with just regard of the balancing of rights and the operational requirements of the employer, I want us now to picture ourselves, the employee. When I started the show, I said, you don't report to a disciplinary hearing, and now we're at the hearing. I raise as the employee a defense of you shouldn't dismiss me because I have a right to religion and all the rights I've mentioned, bodily integrity and so forth. Well, now I lose the disciplinary hearing against my employer, and my employer says, okay, because you've lost, I won't fire you. Instead, I will give you a 10-day grace period to go vaccinate. Well, I go there and take the vaccination because probably I was lying about my underlying health condition or whatsoever. My reason was not to go and vaccinate. And after I've taken the vaccine, well, I have some side effects. Probably they lead to disability or death. Can my family, my wife, or any person who's dependent on me, and if myself I am disabled in one way or another, can I sue my employer for compelling me to vaccinate?
With direct flights from over 95 international destinations, Ethiopian Airlines, with award-winning cabin services, invites you to visit Ethiopia, land of origins. Capture dramatic beauty. Experience the rhythm of nature. Explore rich history. Take in colorful traditions. Witness the footprints of time and indulge your senses. Fly Ethiopian Airlines, the new spirit of Africa, a Star Alliance member.
Broadcasting worldwide, online 24/7.
It's Vuka Online, your inspiration radio station.
Still listening to the Law Report with Thokozane on Vuka Online. You're listening to us on www.vukaonline.radio.co.za. Join the conversation on Twitter, it's Vuka Online, or on Facebook. Our Facebook page is Vuka Online Radio. Leave your comments there. I'm sitting with Toto Keza, who is a labor law expert, and we are discussing vaccination at the workplace. Can an employer make it mandatory for the employee to report to a vaccination center? Just before we went on an ad break, I said, well, let's say, picture ourselves in a disciplinary hearing, and I've lost my hearing. Instead of the employer dismissing me for failure to report to a vaccination center to take the vaccine, he says, we'll give you a warning, and to remedy what you've done, in the next 10 days, report to a vaccination center and take the vaccine. And I do that, and guess what? Few days later, weeks later, there are negative consequences to my body, side effects. Can I sue the employer for compelling me to vaccinate from the first place, Mr. Toto?
Yes, Mr. Dladla, you are raising a very important point that one would have to consider as and when you are indirectly or quote unquote forced to take a vaccine. But coming your question whether you can be able to sue the employer, I think the drafters of the policy on management of this pandemic, COVID-19, thought about these things. And for instance, the state or government has established what is known as VIC. VIC is an acronym for Vaccination, Injury, No Fault Compensation Scheme, VIC. Now, the purpose of this scheme is to allow for easy access to compensation for persons who suffer harm, loss, or damage as a result of receiving a COVID-19 vaccine. So in such an instance that you have painted, an employee can then approach VIC or this scheme, and then the employee would then claim from the scheme damages for whatever loss or harm the employee has suffered. Of course, there has to be a proof that this is a genuine claim, veracity of the allegations made, or the fact that the employee is saying now he or she is unwell because of the vaccine, or to some instances where it has led to a fatal outcome. Then the family or the spouse or the children of the deceased would have to lay such a claim to this vaccination scheme so that they can be able to receive compensation. But employers themselves would also refer such a family or an employee who is in that situation to go to the scheme and then lodge a claim for compensation for such instances.
Mr. Totokeza, of course, we raised the thing of possible defenses, and when you started, you said one can say I have underlying conditions in which if I take the vaccine, it may lead to severe health complications. Now, if I say that, and because there's so much hesitations towards their vaccination and the employer feels like I'm lying, is the employer entitled and allowed in law to appoint his own doctor to inspect me and come up with a report on whether I'm right that I have some poor immune system and that's why I shouldn't take the vaccine?
Yes, Mr. Dladla. Look, I think earlier on we touched a bit on this aspect, the fact that there must be a veracity or a test that would confirm whether the point that has been raised by the employee is valid or not. However, this would have to be done in line with the provisions of the Employment Equity Act, for instance, where the Employment Equity Act talks about when can an employee be subjected to a medical test and what are the conditions under which such an employee would have to be subjected to such a medical test. So there are all other provisions from all other related legislation that talks to that, and employers would then have to align themselves or try and be incongruent with all the provisions of such legislation, which talks to whether there must be a consent of the employee, and outside of that consent, then that becomes an unfair discrimination of some sort. However, now if you look at it from the other side, the National Health Act, for instance, says any healthcare service administered to an employee also emphasizes there must be a consent. However, there are exceptions. One of the exceptions, for instance, in fact, the Act raises two exceptions where such a rule of consensual administering of healthcare services can be waived. One is when there is a law or an order of a competent court that says such a healthcare service must be administered. Secondly, which I think talks to what we are talking about today, is in instances where failure to administer such a healthcare service would lead to a serious public health risk. Where now the employers would then say, in terms of this second provision, if we don't vaccinate, then that would lead to a public health risk. And then they would lean towards that and subject, try and reason with the employees to subject themselves to such a medical testing to make sure that there is veracity to the argument advanced by the employee on such instances.
Speaking of testing, there's so much confusion on who should pay for the vaccination. Is it the employee's medical aid, or should it be the employer, or what about those employees who do not fall in either? They do not have medical aid, and the employer says, it's your house, so pay for yourself. Who should pay exactly?
My understanding of the law provisions on this aspect, Mr. Tlantla, is that one, the state or government is rolling out the program. So there is no one who will be left behind. If you are not under some form of medical insurance, then the state pays for such a service. So employers have no obligation, in all honesty, to pay for such a service, but they can refer the employee to a test center or a vaccination site where government is offering this service for free to everyone. But some employees might be on medical aid, and medical aid, I think I'm subject to correction here because it's not my specialty, but there is some form of a minimal cost that is attached to it.
All right. Thank you for that, and you've cleared the air. And if you just joined us now, I'm speaking to Mr. Toto Geza. He's a labor law expert and the CEO of Geza Advisory Services. Mr. Toto, I also want us to talk now about this pressure that is put towards employees. Is it problematic, and can I even have a legal remedy to an employer which has made it clear through announcement, emails, and notices all over the workplace that those who are not willing to vaccinate will be the first ones to be retrenched when we have to retrench people? So is that legally allowed to say those who vaccinate, we will keep them and may even give them bonuses?
Sorry, I failed to unmute myself there. This is quite an interesting topic, Mr. Tlantla, and it's stimulating a discussion wherever you are, and from to and from, and people for and against. It's a nice discussion to have, where you have different schools of thoughts and motivations to arrive at a particular point. But I think what drives the conversation, in my view, is one, there is a pandemic. As a country, as the whole world, we've never been in this situation. In fact, the whole world has never been since about 100 years ago. So it's a new challenge for everyone. We're traversing on waters, on uncharted waters, if I may call it that. So it's a trial and error as everyone is going forward. We are trying to grapple with this thing, whether it's the state, whether it's the healthcare professionals, or legislators who are trying to set laws and rules of engagement in these circumstances that we are not familiar with. So I think what is at the center of it all is the fact that there is a public health crisis. And on the other side, there are rights or individual rights which are conferred on us by the Constitution. And those rights are protected rights. Now, what all this wants to do is to strike a balance a delicate balance at it on the rights of individuals, which are protected, as against the public health imperative, which is put on us by the pandemic. So in that process, there would be false steps, missteps. Employers, and when those things happen, as you have alluded to, there are forums which are meant to safeguard and protect and provide remedies to those who have been unfairly treated in such instances. We've got the labor courts, we've got the CCMAs and bargaining councils, which are the role players in dispute management. And such employees who have found themselves or who believe that they've been subjected to such, then they've got so much protection in our law, so that they can be able to enforce their rights, and such ill treatment is responded to positively, so that they can at least have that satisfaction that they have been adjudicated upon.
That is mouthful. Let's take a net break, and when we come back, I want us to look at the interaction between POPI, Protection of Personal Information Act of 2013, with labor law. There is an interaction or intersection between the two, and come back to find out how does Protection of Personal Information Act link with labor law.
What do most banks know about simplicity? About what it means to live better?
Do you really need all those accounts that cost you more just because you earn more? And the hoops you have to jump through for the free rewards that you hardly ever use. Aren't you just tired of it? What if I told you there's a simpler way? A bank that takes all the complexity of banking and turns it on its head. Capitec is doing just that, using technology to cut the cost of banking and put the value back in your pocket with Live Better benefits that you can get immediately, making you feel valued when you need it most. Here's a bank that invests in innovative solutions to simplify your life so that you can live better. Simplify banking. Live better.
Strap yourself in, because we're set up, switched on, and ready to go. Vuka Online.
To the law report with Thokozani on Vuka Online Radio, and with me today I'm with Mr. Toto Geza, CEO of Geza Advisory Services. He's the labor law expert and who's been in the field for years and years, and he's helping us unpack the confusion, the conspiracy, separating the facts from the myths. But now I want us to look at the intersection between the Protection of Personal Information Act as well as the labor laws. I've heard someone I work with saying to me, I want to go to vaccinate, but I don't want to give away my personal details because I believe the government will use such information for undue ways, if I may put it just like that. He mentioned to me, which sounded a little bit like conspiracy. He said they will track me and all that. I want to vaccinate, but I don't want to give my personal information to the government. It's his reason, but is that a valid ground also not to take the vaccine, Mr. Dodd?
Oh, Mr. Dladla, I don't think that could be considered a valid ground at all. The POPI Act, or POPIA as it's often referred to, makes provision for employers or any organization for that matter that manages a personal information on how such information must be managed, can be accessed, and how it can be protected. And any organization that has that personal information, which then misuses it for any other reason except the one that was consented for. In terms of the Act, there are consequences for that. There are penalties that are punishable by law, fines, even sometimes to even one found to be criminal liable. So if an employee then raises that, I think the employers have an obligation to assist the employee to understand all these provisions that are there, which are protecting employees on very valuable resource that they have, which is their personal information. So I think under those circumstances, I would think employers would have an obligation to create an awareness around the provisions of how the employees are protected by law under those instances.
Well, I must say it feels, and I've went through the experience of disclosing my past medical history to an HR officer. It's just not so enlightening and comfortable as if I'm speaking to a medical health expert or someone who works for the health department. So I understand that, how employees' frustration is coming about, having to disclose your past medical history to someone who's not a medical expert, and maybe that's where the hesitation towards opening up is coming from.
Look, no, I understand where you're coming from, Mr. Ntantla, and I respect that. Health information is private information. And sometimes, as much as we may like in an ideal world to assume that we are all keeping to the nuances of protecting or behaving in a manner that is expected of us to behave, sometimes it doesn't happen like that. So the fears and the concerns might be genuine, but in the absence of any, we're trying to balance those concerns with the imperative that is on all of us, that employees must be vaccinated if there is an operational risk, not only to the employees themselves within the organization, but also to those people who access such a workplace, maybe clients or customers. So when all that is said and done, I think we've got safety checks in our systems, and I would urge such employees to test those safety checks if they do work, and if they feel that they are not protecting them, then there are also other legal remedies that they can pursue, lodge formal processes, disputes along those lines, and see if those people then can be held accountable for such misdemeanors, which I must say always leave a sour taste on the mouth in many instances.
You're still listening to Vuka Online Radio on www.vukaonlineradio.co.za, and my name is Thokozani, and I will be with you every time. This time, it's time for the rights of the law and stuff like that, and we're talking everything regarding the law and clearing the air, differentiating the facts, the law, and the myths. I want us now to talk about balancing. I like what you've just said about employees who interact with clients, with customers. Well, that's where I want us to go right now. Can one really say, because I work alone in an office, I interact with my family and come to work, lock myself from 8 o'clock to 1, go on lunch, and I come back, lock myself again. Therefore, I don't act in this position or interact with the public. So therefore, I don't want to take the vaccine. Is that a valid ground?
It might be a personal view that a person holds. But if an organization from an umbrella point of view says that, remember, sometimes perception is power. Some clients or any other person, once such information filters through, that some employees choose not to vaccinate, because or whatever, for whatever reason, some employees within that particular organization are not vaccinated. That might be negative information that comes or that flows from that organization, and that probably could be damaging to the reputation of the organization. So there's lots of issues that one would have to consider. But if there is a policy that says there must be mandatory vaccination, and that policy is informed by a risk assessment. Of course, during that assessment, my assumption would be that such employees, as the one you have alluded to in your illustration, might not necessarily be expected to be forced to vaccinate, because in terms of the inherent requirements of their job, they are not necessarily exposed or in a risk of interfacing with lots of clients or customers. So the assessment would have then highlighted them to be on a medium to low risk, and therefore there's no need for mandatory, but vaccination would be out of choice, because I think the purpose of the assessment is to exactly do that, to highlight or lift up those divisions within that organization that are inherently interfacing with the public, or there's a number of people who are in that particular space, and therefore there is high risk of infection or passing through the vaccine and that might compromise the operations of the organization. So I think in those instances, such employees might have been absolved by the assessment of the risk from the onset.
Yes, you've heard it yourself. If you're a teacher, a policeman, a traffic officer, a receptionist, and you obviously interact with us, members of the public, you are most likely to be the first one in the queue. That's great news. But of course, as he said, there's balancing. You look at inherent requirement of the job, as well as the risk assessment that will be undertaken in each and every employment workplace. Look, now I want us to look at some of the concerns regarding how COVID-19 vaccine came about. I've heard people saying, how come a whole virus, which has been described as a pandemic because it was faced all over the world, get to come up with a vaccine within a year, whereas for the HIV, it took decades and decades for the ARVs to come about. And those are some of the defenses which people are placing their doubt on for not taking the vaccine. What would you say yourself to someone who says it was just too quick for them to make the vaccine? I don't trust it.
Well, if that question was to be posed to me, I might leave that to the experts. I think the healthcare experts might be the ones who might be able to respond appropriately to that. Mine, I think my line of work allows me only to see whether the presence of that vaccine doesn't unfairly discriminate or expose employees to a vulnerable point wherein they might lose their livelihoods because of being forced with no assessment or with no consideration of their health, their religious beliefs or cultural beliefs. I think that would be my line of thoughts, because that's what I do on a daily basis. But the fact that the time it took to come up with the vaccine and whether it's trustworthy or it's reliable, I think I would plead the Fifth Amendment, as the Americans would say, and allow that to be considered by the healthcare experts. Mr. Lal, thank you.
Thank you so much, Mr. Keza, for being with us for this 1 hour of speaking about the law, the rules, and all stuff related to vaccination at the workplace. It's been nice having you, and you've clarified a lot of questions in which we had a lot of confusion about and hesitations because there's so much put online on the internet, and we don't know what is true and what are the legal positions to many questions I've asked today. You've clarified for us that the employer has a legal obligation to make the workplace safe, and that was interesting to me from today's show, and also the intersection between Protection of Personal Information Act as well as labor laws, as well as the legal defenses, which one can hold water and which one you shouldn't even attempt to raise at your disciplinary hearing, because if you do, you will just lose that case and get yourself fired. So for those who have been chanting, I won't vaccinate, I won't vaccinate, I won't vaccinate, well, think about it and draw some mind map whereby you look and differentiate what is true, what are facts, what are lies, what are myths, what does the law say, and what does my employer's policy say. Do not put your job at risk, but I wouldn't say Mr. Totokeza should tell us whether he took the vaccine and whether he advises people to take the vaccine or not, because that may be, and one will say, I'm forcing people or kind of influencing people, as these days they call them vaccination influencers. I don't want him to be that person, but I want him to share where can people who want his legal advisory services go, his website, email address where they can pose questions and say goodbye to our listeners.
Thank you, Mr. Lala. I'm happy you are not asking me to disclose. I don't necessarily also want to influence people this way or that way. Otherwise, I appreciated the session myself. Thank you for the opportunity. If there's anyone who would want to chat or ask or seek clarity on some of the issues we talked about, I'm reachable on 082 314-7788. You can drop us also email on gezaadvisoryservices@gmail.com, or you can follow our Facebook page or Geza Advisory Services on Facebook. The consultants or people who are always willing to assist as and when there is a need to do so. Thank you so much. I appreciated the session myself.
This was the Law Report with Thokozane on Vuka Online Radio. Listen to us again next week, same time, same places, www.vukaonlineradio.co.za. And I'm Thokozane, I'm out of here. Till we meet again, where we discuss the law, the rules, your rights, your obligations, stuff like that. Again, on Vuka Online, we inspire you and feed you with knowledge. I'm out.
SABS Test the Test number 23, vacuum cleaners.
Okay, so I'm going to vacuum something up and you tell me what it is.
Got it. Chips, salt and vinegar, 3 days old.
Right.
Apple juice, 60% concentration.
Yeah, well done.
Smarties, 3 blues, 1 green and 4 yellows.
It's